All rise, please. Conduit Justice Court is now in session. David Gideon presiding. Again, if you send on your cell phones and that's the first event until you're called forward. Thank you. You may be seated.
Good evening, everybody. Welcome to the Town of DeWitt Court. I'm going to call the case of People versus Martha Hennessy, People versus Claire T. Grady, People versus Mark Scaviglia Carver, People versus Judith A. Bello, People versus Rae S. Kramer, People versus Daniel E. Bergevin, People versus Marianne Grady Flores, People versus Mark P. Colville, People versus Brian T. Hines, People versus Elliot D.S. Adams, People versus Patricia Whelan, People versus Edward F. Canan, and People versus James L. Ricks Jr. On behalf of the people, Assistant District Attorney Jordan McNamara is present, along with Assistant District Attorney Michael Mordew. Ms. Hennessy, are you present?
Yes.
And Ms. Claire T. Grady?
Yes.
Mark Scaviglia Carver?
Yes.
Judith A. Bello?
Yes, sir.
Rae S. Kramer?
Yes, sir.
Daniel E. Bergevin?
Here.
Marianne Grady Flores? Mark P. Colville?
Yes.
Brian T. Hines?
Here, Your Honor.
Elliot D.S. Adams? Mr. Adams?
He's not here, Judge. I believe he had informed you that he was going to be traveling. I think he's on the West Coast.
So that was a prior excused appearance. Patricia Whelan?
Present, Your Honor.
And Edward F. Canan?
Here.
And James L. Ricks Jr.
Here.
Okay, firstly, before we get started, I have additional media requests from a Catherine Long. The Catholic Sun is requesting still photography usage. Ellen Abbott from WRBO is requesting audio and still photography. I have Chris McConkey from Chris McConkey Productions asking for video, including audio, I would take it. And Charlene Hannigan from the Post Standard is requesting video for later broadcast, audio for later broadcast, and still photography. I have previously made rulings which will stand relative to the other requests that have been made throughout the trial. As to these people's positions,
Judge, I have no problem with it prior on.
okay. And any objection on behalf of any of the defendants?
No, sir. No.
Not hearing any, I'll grant the request. Now, I have one microphone up here. Is there any other mics that have to go up here before we get started?
I'm fine. I'm fine.
Okay. Anybody else? Okay. As soon as I find my notes. There it is. Okay, this matter is scheduled this evening for verdict. Firstly, I will start out with regard to the affirmative defense of justification pursuant to Penal Law Sections 35.05 Subdivision 1 and 2 raised by the defendants. And the court hereby finds as follows. While given an opportunity to cite a specific statute, law, treaty, or judicial decree authorizing the defendant's actions on October 25, 2012, and offering the opportunity to submit a memorandum of law in support of the same, with the exception of an article submitted by Ms. Bello and Defendant's Exhibit G, which was an article concerning drone wars, this court received no specific citations, and none was provided for the court to review. The defendants did raise the Nuremberg Principles Incorporation by treaty, an issue which this court has previously ruled upon in a prior matter, finding that the Nuremberg Principles were adopted by treaty of the United States as and for the guiding principles in the Nuremberg trial only, and not as a general adoption otherwise. The defendants are therefore collaterally estopped from raising this issue in this court. Of course, the defendants can certainly raise that, and they have a right to raise that issue on appeal if they so choose. In reviewing the articles presented by Ms. Bello and Defendant's Exhibit G, this court finds no specific citation to any statute, law, treaty, or judicial decree that this court could review. Rather, the articles refer to non-specific references such as international human rights law, laws of other countries, and of U.S. domestic law. Had this court been referred to a specific citation, it could have reviewed that citation, but of course it was not referred to any such citations. Additionally, this court received no evidence that an imminent public or private injury was occurring on or about to occur at the time of the defendant's actions, or that the defendant's actions would have prevented the same. Therefore, the defendants have failed to establish a prima facie case of justification under Penal Law Section 35.05 Subdivision 1 or Subdivision 2, and the burden to disprove does not therefore shift to the people, and the defendant's justification defense is therefore denied and dismissed. Relative to the verdict, on the charge of trespass in violation of Penal Law Section 140.05. In the opinion of this court, as the trier of fact, the testimony received as to the actual boundary lines of the base premises were confusing at best. Clearly, there are no definitive markers, posts, or signs indicating the premises boundaries, and none of the witnesses could specifically delineate the same. While the base could certainly remedy this issue, the testimony that the court received indicated that the command chose not to do that. Without a clear delineation as to boundary lines, easements, and what those easements were for, this court cannot find beyond a reasonable doubt that the defendants were on the base premises, and this court therefore finds the defendants not guilty of trespass pursuant to Penal Law Section 140.05. With regard to the charge of disorderly conduct pursuant to Penal Law Section 240.20 Subdivision 5, however, a review of the testimony and evidence presented at trial clearly shows that vehicular and pedestrian traffic was obstructed by the defendants at all three gates to the base. This court, in reviewing the videos, People's Exhibit 2, observed several cars approaching at each of the gates, stopped by the defendants, forming a human barrier complete with orange cones. This court also observed at least one car almost hitting one of the defendants, and at the Thompson Road gate at least, two drivers getting out of their vehicles with what appeared to be some sort of confrontation with the defendants. All of the gates in the videos showed that the stopped cars were observed to turn around in traffic and leave. While several of the defendants testified that their stated intent was to redress their grievances with their government, it is clear to this court that the true intent was so-called rattle the chains to be taken seriously, to bring their point home, and not to be ignored. As set forth by the Court of Appeals in People v. William Bracey, 41 New York 2nd, 296, a 1977 case, intent can be inferred from the defendant's conduct and the surrounding circumstances. Additionally, as set forth by the Court of Appeals in People v. Weaver at 16 New York 3D 123, a 2011 case, and People v. Baker 20 New York 3rd 354, a 2013 case, there is no per se requirement that members of the public must be involved or react to the incident. In these cases, in the instant cases, there's no doubt in this court's opinion, sitting as the trier of fact, and having reviewed the video several times, People's Exhibit 2, received into evidence without objection, there is no reasonable doubt that each of the defendants intended to cause public inconvenience, annoyance, or alarm, or recklessly create a risk thereof by obstructing vehicular and pedestrian traffic at the 174th Air Base gates. This court therefore finds each of the defendants guilty of disorderly conduct in violation of Penal Law Section 240-20 sub 5. All other motions not inconsistent with the court's verdict are therefore hereby dismissed. People move sentence.
Judge, I request that you sentence each of the defendants to 15 days in the Onondaga County Correctional Facility.
Okay, I'm going to ask each of the defendants if they wish to be heard. And if you want to come up and use the podium, we can do it that way.